The commissioner shall establish a case review panel consisting of at least 15 members, and 3 may sit as a team to review a particular case. Now, in this section, they're talking specifically about the commissioner of mental health, and it's only just at least 15 members. It could be up to 25, 30, who knows. When it appears to an agency with jurisdiction that a person who may be a detained sex offender is nearing anticipated release from confinement, the agency shall give notice to the Attorney General and the Commissioner of Mental Health, which is Ann Sullivan, MD. Where a case has been referred to a case review team and it finds that the respondent is a sex offender requiring civil management, the team shall provide written notice to the Attorney General and respondent within 45 days of Commissioner Ann Sullivan receiving the notice of anticipated release. Within 10 days after the Attorney General files a sex offender civil management petition, the respondent may file a notice of removal to the county of the underlying charges. The Attorney General, in which the petition is pending, may make a motion for retention of venue. Such motion shall be made within 5 days after the Attorney General is served with the respondent's notice of removal. Within 30 days after the petition is filed, the Supreme Court or County Court shall conduct a probable cause hearing to determine whether there is probable cause to believe respondent is a sex offender requiring civil management. Within 60 days after court determines there is probable cause, the court shall conduct a jury trial to determine whether the respondent is a detained sex offender who suffers from a mental abnormality. The jury would consist of 12 members. They must agree by unanimous verdict. If they cannot agree by unanimous verdict, the court has 60 days to do another jury trial. But if the second jury trial cannot agree to a unanimous verdict on the respondent being a detained sex offender who suffers from a mental abnormality, the court shall dismiss the petition. The peremptory challenges for these people are the same as in an indictment trial, where the highest charge would be a D felony. The 10 challenges and 2 for each alternate. The following are true concerning the trial described in 1. 1. Jury trial can be waived. Burden of proof is on the AG. The case must be proved by clear and convincing evidence, and the finding must be by unanimous verdict. At the trial described in that question, the Attorney General and the respondent may both request closure of the courtroom or sealing of papers for good cause shown. The Commissioner of Mental Health, Ann Sullivan, shall provide the respondent and counsel for the respondent with an annual notice of the right to petition to the court for release or discharge. The court shall hold an evidentiary hearing as to retention of the respondent within 45 days if it appears from one of the annual notices that the respondent has either petitioned or has not affirmatively waived the right to petition for discharge. The Attorney General may, in the Appellate Division of the Supreme Court, seek a stay of any order under this article releasing a person. They can also appeal any order as of right, any release order. And both the Attorney General and the respondent may, as of right, appeal from any final order entered pursuant to this article. Now I'm going to go into the corrections law, sex offender thing, because this is different but kind of similar. Similar things we're talking about. Sex offense includes conviction for any one of the forcible touching, which is 130.52 or 130.55, provided the victim was 0 to 17, so less than 18. $10 fee to change the address, school attendance or employment or residence at any institution of higher education. In the case of any sex offender, it shall be the duty of the department, hospital, or local correctional facility at least 10 calendar days prior to the release or discharge of any sex offender to notify the division of the contemplated release or discharge. The duties of the court. Court shall certify the person as a sex offender, shall include the certification in the order of commitment, if any, and judgment of conviction, shall also advise the sex offender of his or her duties under this article. when there's a hearing to decide what level, it's by clear and convincing evidence, and it's proven by the district attorney. So at this point, for the SORA hearing, it's the DA. For the civil commitment, that's the Attorney General. The hearing is always held without a jury. Okay, so for the copies, this is when the court releases someone on probation or pays a fine or discharge, conditional discharge. They're informed and they have to register at the time sentence is imposed. The court requires them to read and sign the form and to complete the registration. The court has to have their one copy for the file, and they make 3 additional copies. 2 go to the division, 1 goes to the sex offender. Just to recap on this question, the court shall give 1 copy of the form to the offender and send 2 copies to the division. The court shall also notify the DA and sex offender of the date of the determination proceeding to be held, which shall be held at least 45 days after the notice, such notice is given. Any sex offender shall at least 10 calendar days before parole, release, etc. register with the division on a form prepared by the division. If a sex offender is on probation or parole and they notify the probation officer of their new address, the probation officer must notify the division within 48 hours. Upon receipt of such a change of address, but in no event more than 2 business days after the receipt, the division shall notify the local law enforcement agency of the new place of residence and the prior local law enforcement agency where the person lived before of the new address. A determination by the court regarding the level shall be made prior to discharge, applying guidelines after receiving a recommendation by the board. No later than 30 days prior to the board's recommendation, the sex offender shall be notified that his or her case is under review by the board. So for level 3, it's high risk, and level 2, it's moderate risk of reoffense, and those 2 are ineligible for public housing, and it's a lifetime registration. There's a subdirectory for 2 and 3. Level 1, it's 20 years. Risk of repeat offense is low. If a sex offender fails to appear at the hearing, the DA shall present the evidence and have the hearing anyway. Court has to hold the hearing anyway. The duty to appear for the photograph, they have to be notified within 20 days of the first anniversary date. The local law enforcement agency sends at least 30, but not more than 60 days of the notice to appear for the photograph.